이렇게 보내. Justice beri aku ngaruh Robin to Robin bukan mata ba oh oh
Motion one, 20 minutes, 5 minutes. Last day, right? Last day, right? March, take it.
right
March,
that's important
it's already memorable. But if you want to see, you can see.
So just forgot and
ah
That's what we're doing.
May I please, your lordship?
Yes, sir.
Lordship, I beg to mention item number 2.
Okay,
Lordship, here in this case, the cabinet had already given its approval. So, can you grant 3 weeks time for compliance, lordship?
okay. So you are for the petitioner.
Yes, sir.
Okay. Mr. Likhaze Samtam.
Benison Bishop.
Okay, then counsel for the petitioner. Also had Ms. V. Sukre, counsel for the respondent, who submits that the cabinet has already
Given its
Hmm?
approval, yes,
approved
yes,
and seeking 2 weeks time for
3 weeks, your lordship.
3 weeks time for compliance. The prayer is allowed. List is made after 3 weeks.
Lordship.
Okay.
Lordship, again, item number 8.
8.
Yes, lordship, can you grant 3 weeks time to obtain the instruction?
Okay. Who is here in?
Chair for the petition on behalf of my senior.
Okay. Miss Lana Council,
Petition
appear on behalf of Mr.
from identity launcher.
Okay. Lana Council for the petitioner is present staff. Miss Sukhe. For Lana Council for
Respondent, 2 to 7.
respondent number appearing on behalf of respondent number 2 to 7. Praise for
3 weeks time, your lordship.
and is granted 3 weeks time to obtain instruction.
Yes, lordship.
Okay, list is matter after 3 weeks.
Lordship, again, I have similar prayer in item number 13.
13.
Yes. Lordship, here also, can you grant 3 weeks time to obtain the instructions?
Who is here for? Okay. Mr.
Benison Bishop.
Lana Council for the petitioner is present. Miss V. Sukhe, Lana Council for appearing on behalf of
Respondent number 2 to
respondent number
5.
2 to 5. Praise for
3 weeks time, your
and
lordship.
is granted 3 weeks time to obtain instruction. Stop. List is matter after 3 weeks.
Lordship, much obliged.
Okay.
My please, Lordship. Lordship, I beg to mention item number 15.
Item 15.
Well,
Okay.
I'm appearing for respondent number 1 here, Lordship.
Okay.
So if this matter may be listed after 1 week, and I've taken the consent of the opposite party,
Mr.
Lakshmi Pom, Lordship.
Appearing on behalf of respondent number
1, Lordship.
1 on the consent of the Land Council for the appellant prays for and is granted
1 week time,
1 week time.
Lordship.
So prays for an adjourn
Yes,
for
yes,
adjournment.
yes, yes.
Prays for an adjournment for a week. That is allowed. List is matter after a week. Okay.
And Lordship, item number 18 also, I have similar prayer, Lordship.
Similar prayer.
Lordship.
Here also you have obtained consent from the other side.
Yes, yes, yes.
You have here you are for respondent.
1. Here also respondent 1.
Okay, similar order, huh?
Obliged, Lordship.
On the consent, huh? This is. Yes,
May I please, your lordship? Lordship, I beg to mention item number 10, your lordship.
item 10
Yes, your lordship. On behalf of I second, your lordship.
for the petitioner.
Yes, your lordship, for the petition. Lordship, I pray that the matter be posted after on 26, your lordship. Since the 26 February, your lordship,
26 February.
your lordship. Since the leading council is the obsession.
Okay, you have,
Lordship, I'm appearing for respondent number 1.
okay. Mr.
I'm sorry, your lordship.
Land Council appearing on behalf, Land Council for the petitioner. Praise for listing this matter on
26, your lordship. 26 February.
26,
Yes, your lordship.
to which Miss
Mika, Lordship, HI.
has no objection. Stop. The prayer is allowed. Is prayed, comma, list this matter on 26 to 2024.
Your lordship.
Okay.
Much obliged.
And please, Lordship, I'd like to mention item number 11,
Yes.
2 weeks time to file my affidavit in opposition
Okay.
on behalf of respondent 2, 3, and 4.
You are for the petitioner.
Yes, your lordship.
Okay. You are Miss,
Anyone?
and counsel for the petitioner is present. Mr.
Dan Sanaya.
appearing on behalf of Mr. You are appearing on whose behalf?
Endong Gomer.
Land council. The respondent number 2, 3, and 4. Raise 4. And is granted 3. How much time?
2 weeks.
2 weeks time to file affidavit.
Affidavit in opposition.
Affidavit in opposition. Stop. List this matter after 2 weeks. Okay.
Please.
May I please, my lord?
Yes.
Lordship, item number 9.
Yes.
Lordship, the state has preferred an appeal in this case against the judgment order passed by the learned single bench, Lordship. So my prayer is that for listing this contempt petition after the disposal of read appeal 16/2023, Lordship.
So who is for a petition?
For the petitioner. Lordship, till now the delay is also not yet condoned.
Delay not yet condoned.
Not yet,
Yes.
no, but we have filed it. So
They
in
have filed,
case,
but it's not till. it's
But in
yet condoned.
filing of
So,
appeal,
Yes.
any stay in the appeal?
no,
No, even the delay is
no,
not condoned
the
yet.
delay is also not yet condoned, Lordship. But
So
in
they are
case
in the
delay is
appeal.
not condoned, then naturally we'll come back to this, Lordship.
So what do you say?
Let it-
Otherwise, no,
2 weeks.
otherwise not connected.
In a way, Lordship,
Ah,
because even if they file appeal, the governor filed appeal, the
okay.
IA.
So you have no objection.
No, Lordship, let it
Lordship,
come
in
up
the-
for 2 weeks, Lordship.
Lordship, at least 6 weeks, because notice is going, then it'll come back, then we'll be submitting the same prayer again and again, Lordship.
Okay. So
After 2 weeks, Lordship.
after,
2 weeks, Lordship.
so he's saying that same prayer will be made after 2 weeks. or so.
Yes, yeah, Lordship, but
Actually,
for my sake.
Lordship, then 4 weeks. Please let him concede. 2 weeks.
3 weeks, Lordship.
3 weeks. Okay.
Come to a meeting point, Lordship.
Okay. Mr. Fosigo for the land counsel for the petitioner is present. Staff. Mr. Angami. You are for respondent.
Yes, Lordship.
Which respondent?
Uh,
Sole or how many respondents are there?
all, Lordship.
All respondent appearing on behalf of the respondent. Praise for listing this matter after 3 weeks.
3 weeks, Lordship.
So we'll say this time
Okay.
that much only,
Oh,
because that is not connected appeal file or not. You want that to be, that also to be mentioned, that you have preferred an appeal?
Lordship, if that is.
Okay, Ms. Amit, that the state has preferred an appeal against the judgment and order
Dated,
passed by the dated
26/4. 20.
kindly pass it. But
Lordship, 26/4/2023 in read April 2/9/2021, Lordship.
okay. And praise for listing this matter after 3 weeks. Stop. The land counsel for the petitioner has no objection to the prayer so made by the land counsel for the respondent. Accordingly, the prayer is allowed. List this matter after 3 weeks.
Lordship.
Yeah, please, Your Lordship, a declaration for item number 3 to 7.
After 3
Lord-
to,
You're on behalf of Supamati.
okay,
Lordship, Supamati is indisposed. Kindly release the matter on 15.
you are for respondent,
Petitioner.
petitioner,
Yes, Lordship.
okay. Miss
Bikono,
appearing on behalf of Mr.
Supamati Walu.
Supamati Walam. Oh, Miss so and so, huh? Submit that the land counsel for the petitioner, Mr. Supamati Walam, is indisposed and prays for listing this matter after
On 15.
15. Why 15?
Mm,
15, there are some other, I remember some other matter are also fixed. Can it be after 15?
Lordship, can you please fix the
We'll
date?
say, huh?
Can you please fix the date?
When? After 15. 15 to
yes.
there, I remember there some other matter also fixed on 15. So after 15,
Yes, Lordship.
say 19. Huh? 19. 19, okay.
Your Lordship.
List this matter on 19. Okay,
That should be
yes.
Mr. Lordship.
Yes.
Lordship, I beg to mention item number 16.
16,
Yes, Lordship.
yes.
Lordship, in the last occasion, the learned counsel for the respondents has entered appearance and has got time to file Vakalat Nama. And I was informed this morning that she's in this post, so few weeks time may be given.
Okay. You are Miss
Sing along her.
Learned Counsel for the petitioner. Some state the respondent is yet Learned Counsel for the respondent is yet to file Wakalatnama, and at present she is indisposed and made a request to pray for listing this matter after
2 weeks.
2 weeks. Stop. The prayer is allowed. List this matter after 2 weeks. Okay.
For motion, item number 1.
May I praise your Lordship?
Yes.
My Lord, it is an appeal under section 96 of the CPC against the judgment of the District Judge Mugokchung, which was passed on 19/1/2024. Before I come to the appeal memo, I would like to state a brief background so that it will be easier for your Lordship to comprehend with the facts.
Mm.
This matter relates to a plot of land in Mugokchung Town.
Mm.
And this is the ancestral property of the appellants. It is a joint property of the clan.
Is there any document showing that this is an ancestral property of the
Yes.
appellant?
So far as ancestral property is concerned, Mugokchung Town has been established on our land.
Okay.
So that goes without saying, so far as that ancestral property is concerned. What happened was, on 1st August 1947, that is during British time, India got independence on 15 August.
Mm.
So a few days before the independence, the additional Deputy Commissioner Mugokchung
Mm.
has issued a permit to the respondent plaintiff. The present respondent is the plaintiff there in the district court.
Mm.
He was allowed to, given a shop permit to open a shop. So with that permit, he has established a shop in Mugokchung Town.
Mm.
And for that, the permission was obtained from the landowners of the present grandfather of the present appellant
Mm.
to run the shop, to construct the shop, and then for running the shop, permit has already been issued by the additional Deputy Commissioner Mugokchung.
Okay, so
So-
that means the land was with the government now.
The land is with the individuals, the present appellants.
No. So who gave permission? You said additional district.
Yes, that is
additional.
for opening a shop, additional Deputy Commissioner.
But then you said that land belongs to the appellant.
Yes.
Huh.
The respondent plaintiff was issued with a permit to open a shop. And
No, if the land belongs to you, why the appellant, not the
it is,
appellant?
it
the
is in the
respondent had
town.
to.
And to run the business, definitely the license is required from the administration. So, because after the permit was issued,
Mm.
he sought permission from the landowners to construct a building, and he was running the shop.
Is there any document showing that their permission was sought and
No,
The
seeking the
appellant-
permission there was no document about the permission. By way of a customary, it's a small town, so I would like to construct So please allow me. So, and then it was allowed with in lieu of land tax. So land tax was given to the appellant's grandfather. Yearly tax was given for running the shop in his land.
So the for establishment of the Mokokchung town, whether the land was given to the donated to the government or just
No,
no?
initially it was occupied by the Britishers.
Yes.
Lordship is well aware.
Hmm.
Britishers were annexing different places in the world, all over the world. They were occupying the land and they will make a station. Ultimately, that becomes a town. So also Kohima is also like that. Mokokchung was also like that. Britishers, they established first, and in occupation, they were occupying, and then they have left. Now, the plaintiff respondent was running the shop, and he was paying land tax to the appellant's grandfather from time to time.
Any document showing paying land tax to the
No,
appellant?
that payment of tax at that relevant point of time, no document was maintained.
Some agreement, some lease,
No.
something, nothing.
No list. Now, on 6th of March 1992, a devastating fire has destroyed the major portion of Mokokchung town, and so many houses and shops, commercial buildings were gutted by that fire. And in that fire, the shop which was set up by the respondents, that is plaintiff, has also been gutted by fire. After the fire has gutted the shop, not only that shop, many other shops, district administration has issued order not to make any constructions. And after that fire incident, many persons whose shops and houses were gutted, after that they approached the present appellants, that is the ancestral land owners. They have approached and they were allowed, some in the form of sell deed, outright purchase, outright sale, that was done. But the present appellant, the present respondent plaintiff and another person, in fact, they have approached the parents of the present appellants for amicable settlement. But that could not be materialized.
Amicable settlement.
Yes. They wanted to purchase
So
or some settlement with the landowners.
There was dispute between them. That is why amicable settlement would require. Otherwise, it would be.
Yeah,
an
in a way,
something.
it can be said like that.
It must have been disputed.
Yes, because he was in occupation for a long time. So he wanted to own the land.
And this appellant want the land back.
Yes,
So there was a dispute.
yes,
So
exactly.
that is why he approached for amicable settlement.
Yes. That was the position.
Hmm.
So in 2017, the plaintiff, after the fire incident, the land was under occupation of the
So
president.
what happened thereafter? Amicable settlement not done.
Not done. And
So
in
what happened? Any shop
but
established again?
after the fire incident, the land was under the occupation of the present appellants. And this place was used as the Dixie parking, and it was used for hoarding purposes like that. On payment of yearly tax, those receipts are already there because these are recent, after 1992. So after the fire incident, there are records, and it is continuously in the occupation of the present appellants. That is the position. Now, in 2017, the respondent, plaintiff, has filed a complaint to the DC. And then the additional deputy commissioner has referred that to the Dobashi's court. That since it is a settlement with regard to the land, let the Dobashi's court settle it. And then it was referred back. Dobashi's court has summoned the parties, and then they have decided in favor of the present appellant. Agreed by that order, the respondent plaintiff has
The
approached.
entire land was given to the present appellant.
Yes,
By the deposits.
yes, by the Dobashi's court.
Deposits.
Now, against that, they have approached this honorable court challenging the DB's court. This honorable court has dismissed the writ petition. However, a liberty was given to file appropriate suit before the appropriate forum. So, accepting the judgment, they have filed the suit.
You have annexed that order
Yes,
and let us see.
the DB's court order. OIC court orders. Page 63, Lord. That is the vernacular version, and the translated copy.
No,
you will
no.
find it page
No.
66.
No, this is no.
DB's
Um,
court.
The High Court's order directing giving liberty to the
Lord, you will
Rest-
find at page 73. Operative portion, Lordship will find at page 75,
yes, just a minute.
at paragraph 7. By relying on the Reti Sayam's case, the writ petition was dismissed and the liberty was given to the respondent plaintiff to challenge the DB's court order.
On the
This
base,
orders.
basing on the three judges bench decision. Okay.
The present appellants came to a factor after this,
Just a minute.
that summons were issued and WS was filed.
Okay, so he came before the court under by filing writ petition.
Yes,
Hmm. Okay, so liberty was given then.
liberty was given
Hmm.
and then they have filed the suit. We were met parties and we filed written statement and contested the case. Ultimately, the case was heard on,
Suit was filed before the district judge.
yes,
Mokuk Chung.
yes. And it was heard on 23rd May 2022. After conclusion of the hearing, after pleading, everything was evidence, everything was taken. Final hearing argument was done on 23rd May 2022.
Yes.
And then after 2 days of the conclusion of the hearing, on 25th May, after 2 days, hearing was taken on 23rd May 2022. On 25th May 2022, the counsel for the plaintiff has filed 2 documents. That is, one is the DC's order and other is an order passed by this honorable court. And basing on these 2 orders.
This court order means the same order which
No,
giving liberty.
different.
Another order.
All one, which they could not produce even during the argument. After conclusion of the hearing, these 2 documents were filed. And basing on this, after 1 year, 8 months, the judgment was given on 19th of January 2024. I'm afraid whether the learned court below was keeping in mind whatever argument submissions were made on 23rd May 2022. The judgment was passed after 1 year, 8 months. And the judgment was passed by relying on 2 orders which were placed after conclusion of the hearing. through this conclusion. So, something strange. And we did not get any opportunity even to clarify on these two documents because hearing was already concluded. No evidence was adduced on these documents also. But then by relying on this judgment, two orders, the learned court below has given the judgment, and very strange thing has happened. The learned district judge arrived to the conclusion that on 1st of August 1947, only a shop permit was given to the plaintiff respondent, but the district judge arrived to a conclusion that the British government has allotted the land to the plaintiff. And that conclusion, the judgment has been given lordship. A shop permit has been treated as a land pata by the district judge. From where the learned court below has arrived that conclusion, I fail to understand.
That document was not exhibited at the time of trial.
Not at all. Lordship,
common
kindly
evidence.
see. Kindly see the application 244. Page 244, annexure F. As I have mentioned, Lordship, hearing was concluded on 23/5/2022. And
Page 244.
yes, 244, annexure F. Has your Lordship got it? Let me
This is
just read
judgment.
the heading. Let me just read the heading. Filing of order dated 23/2/2011, passed by the Honorable High Court, setting aside and quashing the impugned order dated 25/5/2007, passed by the Deputy Commissioner Mokokchung, which was relied upon and placed on record by the learned counsel for the defendant while arguing the case on 23/5/2022. And then down below, Lordship will find the two documents are document 1 and document 2 they have shown and
Where?
submitted
Where?
by down below, last part of the second paragraph, document 1,
Order
document 2.
dated,
Has your Lordship got it?
order dated 25/5.
Yes, 25/5/2007 and document 2, order dated 23/2/2011, passed by the Honorable High Court, submitted by Mr. Joshua Sheki, plaintiff's counsel, put in the soft copy, so and so, dated Lordship will find 27/5/2022. Hearing was concluded on 23rd May 2022. No leave was availed from the court to file additional documents after conclusion of the hearing. And the law doesn't permit that also. So we did not get any opportunity to clarify these two documents because these two documents has nothing to do with the suit land, the present suit land. Therefore, Lordship, basing on these two documents, what are these two documents?
This document 244 page annexure F is the document filed by the respondent plaintiff or this is the court's order. It's a part of a court order. 244.
Yes,
Is this a part of court order?
yes. This has formed a part of the court, the impugned orders, Lordship. I have enclosed those to put the documents. I will be allowed to read because the learned court below has based her finding on these two documents.
Hello. What?
To make it more simple
minute.
and clear, Lordship, may I just take your Lordship's attention to the finding of the trial court and
Just-
thereafter
just-
come to these two
Just a minute.
documents,
No, this is order.
whether it will be relevant or not.
This is office. of
These
the
two
state-
orders I have enclosed at page 250. DC's order and the High Court order, Lordship.
This is, just a minute, this is Office of the Deputy Commissioner in the Court of Principal. No, this is filed by the respondent plaintiff only.
Yes.
No,
After
not,
conclusion of the
not a
hearing.
part of the court order. This one, page 244
Yes,
is not a part of the court order.
yes,
Seems.
not a part of the court order.
Yes.
After conclusion of the hearing, after hearing was concluded on 23rd, and then after 4 days, it was filed.
25 May,
27th May 2022.
25 May. Yes. And this. The same copy you have 245 and 250 also. Why?
250 is the document which he has filed.
And then 245 is all the same.
Yes. Type copy, I'm referring to type copy 250.
Okay,
This
this
is
is
more
type
clear,
copy.
that's why.
Okay. Just a minute now.
Lordship.
And then another document,
Another document is the order
23
passed by
to-
this Honorable High Court.
23-2.
254, Lordship will find it,
Yes,
254.
for just a minute. This is the document order passed by
This
this
Honorable Court.
court on 23-2011. This was not produced earlier.
Yes, at the time of hearing, it was not produced.
Hmm. What the order says, what is order, this order?
Yes. Kindly come to the impugned judgment. Annexure G, page 257. I will just take your Lordship's attention to the relevant portion only.
257 is the type copy.
No, impugned judgment, Lordship. I'm referring to the
Impugned
impugned
judgment?
judgment.
No.
The order is passed by the DC and the High Court.
Yes, what is the order?
Yes, let us
Passed by
come to
the High
page 250.
250.
Yes, these two orders will be relevant because the learned court below has based her judgment on these two orders.
Mhm.
So may I read, Lordship?
Yes, please.
This is 250. Type copy is more clear, Lordship. So this is 25th May 2007.
Okay.
Deputy Commissioner Mugokchung issued notice letter number so and so dated 29 March 2007, directing the Assam Rifles to produce documents in support of their claim ownership of the land next to the Deputy Commissioner's office on which the new DC complex is proposed to be constructed. Director General Assam Rifles and his authorized representative was asked to appear in the court of the District Magistrate Mugokchung on 17 April 2007 at 11 hours with their land documents. This notice was issued in response to letter number so and so dated 10 February 2007 issued by Colonel M.H. Respi, Chief Engineer, on behalf of the Director General Assam Rifles. In response to the notice issued by the Deputy Commissioner Mugokchung, Shri Edison Mathai, advocate, was deputed by Assam Rifles to appear on their behalf. On 17 April 2007, the learned advocate of Assam Rifles made a plea before the Deputy Commissioner Mugokchung that Assam Rifles could not prepare necessary documents for submission and asked for time. Considering the request, Deputy Commissioner fixed 15 May 2007 as the date for production of documents by Assam Rifles in support of their claim over the land in question. On 15 May 2007, none of the advocates of Assam Rifles were present when the case was called for, and accordingly, Deputy Commissioner Mugokchung ordered that Assam Rifle is granted time till 11 hours on 16 May 2007 for production of their papers. Later, Shri T. Pendang Jamir, Central Government Council, Gauhati High Court, appeared on behalf of Assam Rifles and submitted an affidavit requesting to fix 25th May 2007 for submission of land papers in support of Assam Rifles' claim over the said land. In the interest of justice, Deputy Commissioner Mugokchung agreed to grant time till 25th May 2007 for submission of papers by Assam Rifles. On 25th May 2007, the learned advocate Shri T. Pendang Jamir, on behalf of Assam Rifles, submitted a written statement on behalf of the Director General Assam Rifles. As per his statement, he claimed that The land in question was occupied by 3rd Assam Rifles, then known by the name of military police in 1889. It was also claimed that this land is part of the land that was acquired by the government in 1889 by paying a compensation of rupees 100 to the landowners. The document produced by the learned advocate, including the following. 1. Page 47 of the book titled Sentinels of the Northeast, written by Major General Teki Palit. 2. Extract collected from 100 years of Mokokchung land record compilation, 1890 to 1990, in which the compensated land was demarcated as British area. 3. Extract collected from amalgamated index, Assam Rifles Secretariat chronological entries of events Mokokchung. In the end, the learned advocate claimed that Assam Rifle is in continued possession of the land since 1889, and they have acquired the right to possession by Government of India Act 1935. The learned advocate also submitted that since the dispute is between the state government and the Union of India, the same may be referred to the competent court. In view of the submission made by the learned advocate of Assam Rifles, this court examined the papers submitted by the Assam Rifles and the relevant legal norms very minutely. On the issue of Deputy Commissioner not being competent to examine the ownership of land matters in Mokokchung district, it is found that this matter is not a dispute between the state government and the Union of India. Deputy Commissioner is competent to examine the land matters, and ownership of land is decided by the Deputy Commissioner as part of his duties and responsibilities. Deputy Commissioners have been empowered in this respect by the state government, and they are the nodal officer for all land matters, including land management, registration of sale deed, mutation, land acquisition, etc. That is absolutely correct. This is true not only in Nagaland, but in other states of India also. Thus, to say that this issue is a dispute between the state government and Union of India is not correct. It is a simple matter of anyone occupying any land having the legal right and papers for doing so. If anyone occupies any land without legal documents, the same amounts to encroachment, and any agency, especially those expected to assist the civil administration in maintaining law and order, should not take such excuses to justify encroachment. Law and order agencies are expected to abide by law themselves. Thus, Deputy Commissioner Mokokchung is fully competent to go into the merits of the case and decide the matter. With regard to the papers submitted by Assam Rifles, the first document is an extract from the book Sentinel of the Northeast, written by Major General Teki Palit. I examined the extract, even though it is not an official document. The extract primarily refers to what was political control area and certain adventures of British officers and construction of certain roads. It also refers to the sanction to establish MP post in Mokokchung and Mongsai MD. However, it does not refer at any point of Assam Rifles occupying the land in question. The second document produced by Assam Rifle is from compilation of land records 1890 to 1990, whereby it is mentioned that in 1989, Mokokchung subdivision was built and the government purchased the right over the land for rupees 100 for building the new subdivision station. I examined these papers very carefully and also the records existing in the Deputy Commissioner's office. This is very important. As per the compilation of land records, 1889 to 1990, P.C. Dukes, Secretary to the Chief Commissioner of Assam, sanctioned an amount of rupees 100 for purchase of the rights of the villages of Mokokchung, over which the new subdivision station has been built. However, this is important again. There are no records of the utilization of this sanctioned amount or to which villages and to which landowners the amount was paid. There is no record of that. Further, the area on which the new subdivision station was built was also not demarcated. In spite of the lack of details of the exact land that was acquired, considering that this land was part of the land that was acquired by the British, ownership of the same will rest with subdivision officer Mokokchung, to whom the sanction was sent by the then state government, that is the Assam state government. In 1889, Mokokchung was established as a subdivision of the erstwhile Naga Hills district of Assam, and since then, in 1963, Nagaland state was created and Mokokchung became a district in 1957. Therefore, if the claim of the land is compensated by the British is admitted, still the ownership of the same will lie with the state government and not with the Assam Rifles.
State government.
Yes,
And
still
for the Assam.
ownership of the same will lie with the state government and not with the Assam. The third document produced by Assam Rifles relates to the provisions of the Government of India Act 1935, which detail on the treatment of immovable property after the enactment of the Government of India Act 1935 and pertains to land and property about which title has been clearly established. In the case of consideration, it has not been established that the land has been acquired by Assam Rifles or military police by paying any compensation to landowners. Neither has it been established that the land has been acquired by the state government and given on lease to Assam Rifles or military police. Thus, the claim of Assam Rifles with regard to this land on the basis of the exact extracts from Government of India Act 1935 does not lie. Thus, none of the papers submitted by Assam Rifle could establish ownership of Assam Rifles to the land in question. Land can belong to any individual or organization or government only if it has been legally acquired from the rightful land owners. Ownership of land is also proved by. However, in order to establish the matter clearly, I decided to examine the other papers, but the relevant and are existing in the records of the Office of the Deputy Commissioner. I examined the records pertaining to the establishment of battalion headquarters for Assam Rifles in Mokokchung by acquiring 193.4 acres of land of Ongma village, for which a proper lease deed has been signed between Assam Rifles and the state government on 20th November 1990, for which Assam Rifle is paying the lease rent to the state government. While the process of acquisition of this land was on, there are several correspondences and orders which clearly mention that Assam Rifle or Indian Army did not have any permanently occupied land before 1957. As per letter number so-and-so dated 24th September 1958, sent by Major P.N. Metra, officer in commandant 10 Battalion Assam Rifles to Headquarters Inspector General Assam Rifles, Shillong. It clearly mentions that none of the permanent posts is occupied by the battalion troops in Mokokchung. Similarly, on 17 February 1977, Shri M. Hang Singh, Additional Deputy Commissioner Mokokchung, white letter number so-and-so, addressed to the Commandant 10 Assam Rifles, informed that Assam Rifles have no legal title to any land in the district, and the land occupied by Assam Rifles in Mokokchung is of the nature of temporary occupation. In fact, as per records, Assam Rifles came to Mokokchung only in 1956 to 57, when the law and order situation was not good and the Assam Rifles was requisitioned to aid the civil authority. This is also confirmed by the agreement between Assam Rifles and Ongma villagers and landowners signed on 27 April 1962 for allotting land for advance base at Mokokchung. The very temporary advance base implies that this land was occupied by Assam Rifles temporarily in 1956 to 57, and he sought to regularize it to establish advance base by entering into agreement in 1962. Thus, the claim of Assam Rifle has been occupying this land since 1989 is not correct, as they had this plot of land in DC Hills. There ought have been no need to establish an advance base in Ongma in 1962. A very clear picture of land in question is given by letter dated 4th February 1988, written by Lieutenant Colonel R. Prasad, Station Commander of to the Deputy Commissioner Mokokchung, wherein he has clearly mentioned that the land and DC bashas, including the land in question, under actual occupation of army, were handed over to 56 Mountain Brigade 24 years back by representative of DC state government. He mentioned that at that time, neither any document nor maps were given to army. He further mentioned that since military cantonment will be constructed outside Mokokchung, and then the land under occupation of army at DC Hills will be handed over to the representative of the state government. Since then, the land for Assam Rifles has been acquired in Ongma in 1990 and also in Tuli. However, the land has not been vacated by Assam Rifles in DC Hills. In fact, the claim of the Assam Rifles over this plot of land since 1889 is further refuted by their own letter dated so-and-so, written by Major Mano R. Mahesh, QM for Commandant, 30th Assam Rifles, dated 12 July 2005, wherein it has been requested to the Land Records and Survey Officer Mokokchung to survey the land in Tuk Hill, TSC Hill, and TC Hill for working out the cost of the land. Further, Major S.S. Air QM of 30th Assam Rifle has by letter dated so-and-so, the 24th August 2005, requested Deputy Commissioner Mokokchung to regularize occupation of the company operating bases at DC Hill, Tokra Hills, TSC Hills, Chanki, and Disoi in favor of the 30th Assam Rifles. However, it has been made clear to Army authorities and Assam Rifles that the land in question has been earmarked for the construction of Deputy Commissioner Office complex for more than 15 years. In fact, Major General V.N. Wata had agreed to vacate this plot of land, white point number 3 of his letter number so-and-so dated 25th April 1992, wherein he clearly mentioned that the triangular plot of the land adjoining DC office will be reverted to Deputy Commissioner Office for construction, DC office complex. Thus, on the basis of the above mentioned records and documents, I come to the conclusion that Assam Rifles has no legal right to the land in question, which measures so-and-so square kilometers and is triangular in shape, adjoining to the office of the Deputy Commissioner. The occupation of the Assam Rifles of the said plot of land is temporary in nature, and they are occupying the land only with the objective of providing assistance to the civil administration in maintenance of law and order. It has also been learned that from the records that one company of 30th Assam Rifle is occupying the said plot of land, and most of the land is being in the 193.4 acres of land acquired for the battalion at Ongma. This land has been earmarked for construction of DC office complex and is best suited for the construction of the Deputy Commissioner's office complex. Since it is centrally located and is adjoining to the office of the Deputy Commissioner, the Deputy Commissioner Mokokchung should be able to provide alternate accommodation to the units who are presently occupying the land in question. In view of this, Assam Rifle is hereby directed to vacate the site in question presently occupied by the 30th Assam Rifles within a period of 15 days of the date of issue of this order.
How this is connected with the present land?
That is why. It is not at all connected with the present land. Then how come, based on these orders, the learned court below has arrived to a finding? That is the ground of appeal, Lordship. How? And that too,
This land, whether this land falls under the land and dispute between the
No,
Assam
no,
Rifle and
not
the.
at all.
Okay.
There are so many offices in between also.
Hmm.
Not at all.
So this is not connected with.
Not connected at all.
Hmm.
Then, on what basis the learned court below has based?
The present land in question is in the market,
Yes.
not in
heart
the
of
place
town.
where the DC
Yes.
office is being established.
Yes, near the police point.
So this dispute was basically between the Assam Rifle and the DC
The-
office for the
the-
establishment of the
Exactly,
DC office
Lordship.
only,
Exactly.
not in the present,
Yes,
not covered.
not covered at all.
Is it far away?
It will be, yeah, 5 to 600 meters
Okay,
away distance.
okay.
It's a hilly area,
So this is not connected.
not connected at all.
But in the judgment, in the impugn order,
Yes,
this has been based.
yes.
Okay.
These two
So
orders
for
were
what, deciding what?
for deciding
Uh,
that British, as per the order passed by the DC and the High Court order, British government has allotted the pada to the plaintiff. That is how the learned court below arrived to the finding. And Lordship may kindly have a look at the High Court order also. High Court order has
Okay.
never
What-
mentioned, there is
okay.
not even a
Let
whisper.
let us see the High Court order.
Yes, Lordship. Can you come to page 254?
Yeah.
It's a short order. I may be allowed to read this order also.
Hmm.
This is an order passed by my Lord Justice P.K. Sharma.
Hmm.
It is passed in WPC number 96K of 2007.
2011.
The
Okay.
order is dated 23/2/2011. May I read? Order. Heard, Mr. A. Zimomi, learned additional Solicitor General, as well as Ms. Y. Longcomer, learned additional Senior Government Advocate. By means of this petition, the petitioner have challenged the order dated 25/5/2007 passed by the Deputy Commissioner Mokokchung. This is the order which we have just read out, by which it has been held that Assam Rifle has no legal right over the land in question adjoining to the office of the Deputy Commissioner. According to the said order, the occupation of the land by the Assam Rifles is temporary in nature. It has also been held that the land has been earmarked for construction of the Deputy Commissioner's office and is best suited for the construction since it is centrally located adjoining to the Deputy Commissioner's office. By the said order, Assam Rifle has been directed to vacate the land within 15 days from the date of the order. Mr. Zimomi, learned additional Solicitor General submits that the said order is not sustainable in law on the following grounds. 1. The Deputy Commissioner Mokokchung could not have decided the title over the land by the impugn order dated 25/5/2007. 2. The Deputy Commissioner Mokokchung is being interested party to the proceeding ought not to have decided the issue, being the judge of his own cost. Number 3. Since there is predetermination of the matter as well as evident from the documents annexed to the writ petition, the said order is not sustainable in law. The Director General of Assam Rifle was issued with notice dated 29/3/2007 by the Office of the Deputy Commissioner Mokokchung, which read as follows. And then the notice is dated 29 March 2007. And may I read the letter? Sir, with reference to your letter number so and so, dated 10/2/2007, and the subjects headed above, I am directed to inform you that the land claimed by the Assam Rifle is bogus. The land has been occupied by the Assam Rifles only recently. Earlier, it was temporary occupation by the army. The custodian of the land is Deputy Commissioner. In this connection, you and your representatives is hereby requested to appear before the Court of District Magistrate Mokokchung on 17/4/2007 at 11 hours, along with your land records documents. And then DC has signed the order. On perusal of the said order notice, what is seen is that there was already formation of opinion that the land in question does not belong to the Assam Rifles and that custodian of the land is the Deputy Commissioner. Accordingly, by the said notice, a direction was issued to appear before the Deputy Commissioner on 17/4/2007, along with the land records documents. The aforesaid opinion having already been formed, it was futile exercise to proceed with the matter by the same authority, that is the Deputy Commissioner, holding that the land belongs to the office of the Deputy Commissioner and not to the Assam Rifles. By Annexure P, reply, the authority of the Assam Rifles refuted the claim of the Deputy Commissioner reflected in the impugn order dated 25/5/2007. On perusal of the said order, it appears that number of documents were produced by the Assam Rifles to claim that the land in question is under their possession since 1889. However, the learned Deputy Commissioner Mokokchung, without any cross verification of the documents, passed the impugn order dated 25/5/2007, holding that the land belongs to the office of the Deputy Commissioner. Apart from the above, The Imbion order dated 25/5/2007 is in the form of deciding title over the land. The Deputy Commissioner exercised his revenue jurisdiction, could not have decided the right title and ownership of the land, and that too in a summary manner without taking any evidence. If the government of Nagaland is aggrieved by occupation of the land by Assam Rifles, and or it is their claim that the land belongs to the government of Nagaland, it will be open for the authority to pursue such legal remedy as may be available in law. In view of the above, the writ petition is allowed, sitting aside and quashing the Imbion order dated 25/5/2007, passed by the Deputy Commissioner Mogokchung. Lordship has seen.
The earlier order has been set aside.
Yes. So nowhere this honorable court has said that the title British occupation has been affirmed. Nowhere in the order of the High Court it mentions about the British. But the learned court below has arrived to a finding basing on these two orders. And the order passed by this honorable court is very clear that the Deputy Commissioner Mogokchung has arrived to a finding with a predetermined mind, and he should not have sit as a court to decide this matter when he himself is a party to the case.
So probably, since this land is suited for construction and it is centrally located adjoining to the Deputy Commissioner's office, probably according to the respondent plaintiff, this land comes under this.
No, no,
What you
Not at all.
wanted to show? No,
no.
not at all. Okay, then.
Come
So
to Imbion
where
judgment.
where in the impugn order this
Yes,
document was
yes.
based?
Imbion order, it starts from 257, but I would like to take your lordship's attention to the relevant portion, the finding which has been arrived by the
Where is the portion of the is a relevant
Yes.
portion where these two documents have been relied?
I will refer to two paragraphs. Can we come to 286?
Yes.
Last paragraph at page 286. This court has perused the order to the source. Last paragraph, has the lordship
Yes,
got it?
yes.
Yes, may I read from there?
Yes.
This court has perused the order dated 25/5/2007, passed by the Deputy Commissioner Mogokchung, and also the order dated 23/2/2011, passed by the Honorable Gauhati High Court Kohima bench. The Deputy Commissioner in the order dated 25/5/2007 examined the documents of the British government, whereby it is mentioned that in 1889, Mogokchung subdivision was built on the land purchased by the government for a sum of ₹100. The DC Mogokchung in order observed that the area on which the new subdivision was built was not demarcated, and there were no details of the exact land acquired, for which the ownership of the same will rest with the subdivision officer Mogokchung. The order was challenged before the Honorable Gauhati High Court Kohima bench in WPC number 96 of 2007. The Honorable High Court by order dated 23/2/2011 quashed and set aside the order passed by the Deputy Commissioner Mogokchung. So this is one part, and kindly come to issue number 16, operative portion at page 293.
Yes.
This is the basis of the order. The learned court below has based on the two documents, which was filed after 4 days of the conclusion of the judgment. Paragraph 25, may I read, Lordship?
Yes.
Whether the plaintiff is entitled to the right title and interest to the suit land and relief spread forth. This court has extensively and exhaustively perused the records and even the evidence conducted. The main consideration is whether the British government acquired the land in the year 1889 for setting up a subdivisional headquarters. On perusal of the records, the order passed by the Deputy Commissioner dated 25/5/2007 and the order passed by the High Court dated 23/2/2011 the claim of the British government of purchasing the land at the cost of rupees 100 in 1889 remains unchanged. This court has observed that the same British government allotted the land to let Liverpool, the grandfather of the present appellant plaintiff. So this is very clear. Regardless of whether it was a shop permit or a residential purpose, there is nothing on record to show that the same has been challenged by the family of the defendant's respondent before any forum. It is a fact that the family of the appellant plaintiff has been occupying the suit land measuring 120 by 80 square feet, unless the plot of land had the permit issued by the earlier Mokokchung Town Council bearing permit number so and so. It is clear that a plot of land in the heart of the town with the British permit and without further regularization by the permit of the Mokokchung Town Council would have long ceased to exist. This court has also considered the NOC dated NIL 1993 addressed to the Deputy Commissioner Mokokchung by the town planner Mokokchung and the detachment order of 22nd July 1994 issued by the DC Mokokchung. The documents on record read with the evidence adduced before the court shows that restoration of the rights of the appellant plaintiff over the suit land has not been challenged by the defendant respondent before any forum. In view of the finding in issue number 1 to 15, this court has arrived to the conclusion that the plaintiff is entitled to the right, title, and interest over the suit land as read for. Now, what is the permit, Lordship? The court which has taken as a land pattern. Can you come to page 50? This is the type copy. The original copy is not very clear, which is it annexure for C page 49, but type copy is more clear. Office of the Subdivisional Officer Mokokchung. As there is not at present any satisfactory SEMA shop in Mokokchung, Nivaco SEMA is allowed as a special case to open a shop in Mokokchung. His resignation is accepted from 1 August 1947 and appointed as an honorary Tobashi from that date. This is the permit to open a shop by the Additional Deputy Commissioner Mokokchung. Whereas the learned court below, the District Judge Mokokchung arrived to the conclusion that this is a land permit. That too by the British government. Is it issued by the British government, my lord? With my two eyes, I could see only the Additional Deputy Commissioner Mokokchung. So from where the learned court below came to that conclusion? Unless there is some preconceived mind that yes, it is the British government who has given. So the finding is contrary to the records. That is why it is finding its purpose. Contrary to the records. And that too, the learned court below has based on a document which was filed 4 days after conclusion of the hearing. And unfortunately, judgment was pronounced after 1 year, 8 months. Once the hearing is concluded, our role becomes helpless. We cannot do anything. But then this is the way how the justice is being administered.
Can you issue notice?
Lordship, in the meantime, the ambient judgment may be suspended, Lordship.
No, so this is under whose possession at the moment?
Our possession. We have been taking decks after the fire incident till then. Even now also it is, we are using the land by imposing decks, yearly decks of 10,000 for taxi parking and for hoarding purposes.
Let us see your prayer portion. Prayer. What is your prayer?
Page 31, Lordship. Oh, no.
19.
Page 19.
Okay. And Mr. Zamir, Hi Zamir, Lana Senior Counsel.
Assisted by M. Kong Jamil.
Assisted by Kum Jamil, Lana Counsel for the appellant. Stop, huh? This appeal is directed against the order against impure judgment, impure judgment and order dated 19/1/2024, passed by the district judge Mokokchung, Nagaland, in civil suit number 1 of 2018. Stop, huh? Whereby 2018, whereby huh? The by which the what land is this is the disputed land, we'll call disputed.
Yes, suit land.
That is the suit land, the right title and interest of the suit land has been it says that it's restored. Suit lane is covered by say number 357. Can you
Yes.
mention this number?
Yes, Lordship. Covered by
Or by
serial number.
the suit land, huh? Suit land covered by serial number 357, comma, permit number 99, comma, measuring 120 into 80 square feet.
at Mokokchung Town.
This is plot number.
No plot is given, Lordship.
The plot number 251 is what is it?
Yes, yeah, plot number 251.
Just a minute, huh? Don't write that. So this is part of, I think, that number. Okay, plot numbers 251. The plot number claimed by the defendants has been declared in favor of the respondent plaintiff. . Okay, stop, huh? Para. Issue notice. Returnable by 4 weeks. Stop, huh? Call for records. Para. The appellant shall take steps upon the respondent within 4 days from today by a registered post with ID. Stop, huh? So since it is under your possession,
Lordship, page 294.
let them appear.
Yes,
Let them appear. So
but to avoid any confusion, Lordship, the impugned order may be suspended. Because they may drawn up the decree also.
no, let the opposite party appear. So on the next date, we'll take up.
There may be complications, Lordship. And Lordship, I believe the Lordship is satisfied with the documents.
No,
The
no,
learned
this is-
court below has based her conclusion.
This is with that part, which is not connected with, but
And,
the
How
decision.
can a show
The-
permit be treated as a pata, land pata? Those are basic fundamentals, Lordship. And the learned court below has arrived to a conclusion that when the additional deputy commissioner has issued a show permit only, how it can be treated that it is a land pata, that too issued by the British government. From where? From which document, Lordship?
No,
That is very vital.
okay, Para,
Lordship, I will just,
no, the interim prayer shall be considered after hearing the parties on the next date. So we'll say that since you say that it is under your possession,
yes.
status quo.
But Lordship, decree may be drawn. Lordship may kindly see 294. The order passed by the learned trial court. Yes. The last line.
Hmm.
A decree may be drawn up accordingly within 15 days from today. So they may proceed for drawing the decree. That is why Lordship,
The 19.
on consideration of all this, in the best
Oh,
interest of justice,
So decree not yet drawn.
that's why Lordship. That may be drawn anytime. That is why Lord, if there is no
No,
stay,
no. So let the decree drawn. You challenge that.
we have challenge. For a moment, Lordship, we
It-
kindly come to page 21.
Hmm?
Page 21. I will show a document to your Lordship about the possession of the land. What is the possession of the land in Mokokchung Dam?
Page 21.
Yes, this
21.
is Annexure A, 22nd September 2010. This is a no objection certificate,
No, Page,
which has been sought by the Deputy Commissioner,
page 21
21.
is the first appeal.
Yes. This is a document by which the Deputy Commissioner Mokokchung has sought permission, NOC, from the landowners of Mokokchung to issue NOC for construction of Mokokchung, Deputy Commissioner's office, Mokokchung.
No, yes, you see, decree has not yet drawn. Not yet been drawn.
Then if there is no stay, then the appeal will become infructuous once the decree is drawn.
Now, how they will execute? Decree has not yet drawn.
They will proceed to throw the decree in the absence of any stay on the basing on the judgment.
No, because now you see the lane is still under your possession.
Yes.
And then since it is under your possession, decree has also.
By
not
the
yet been
appeal
drawn.
order,
After,
my
even after
title
the
has been-
decree is drawn, then you see they will have to execute. And for execution, since it is under your possession, they will have to file execution petition.
No, they have to enforce the order.
And
passed
then
by
once the decree is drawn, you
court.
come.
After the order is passed by the trial court, they have conferred the title to the plaintiff.
No.
Now I'm
they
no
have to
longer the
approve.
title
They
holder
will have to approve.
in view of this order.
Mm.
And unless the order is suspended, you will be the owner. At the time of pronouncement of the judgment, it was in my possession. But my possession has been taken away by this. All rights, title, entries has been conferred, restored to the plaintiff. So I'm no longer the owner now. And if I occupy, it will be a forceful occupation again, contrary to the order passed by the court. That is why we are before this honorable court, Lordship. The learned court below has based her judgment basing on the documents which was not even executed in the trial. After conclusion of the judgment, after 4 days, the documents were filed. And then the order was passed after 1 year, 8 months, restoring the title to the plaintiff respondent. I was in possession, but my possession has been given to the plaintiff now by the Indian order.
And then this plot number 21 is also claimed by the defendant is not to pose any threat to the present suit. Plot number 251 is connected with this. Is it under 120 into 80 square feet?
One is serial number and the plot is what? 251.
250.
All are one.
Okay.
Basing on two irrelevant orders, this conclusion has been arrived by the trial court. Therefore, this has to be interfered with by this honorable court.
So we'll say then, since you said that it is under your possession, we'll say
No,
that the
by virtue of this order,
status quo over the land shall be maintained till then. Status quo over the land till then.
what is the
Then,
difficulty, Lordship, to
because your
suspend the
interim
order?
prayer will be considered on the next date only. But then till then, if you are
No, Lordship.
apprehending,
The Lordship is well aware about the criteria.
Mm.
I should first establish a prima facie case
Yes.
in my favor.
Mm.
Number one.
Mm.
Number two,
Mm.
irreparable loss and injury will
balance,
be caused.
balance of convenience.
Number three,
Mm.
the balance of convenience.
So
in
now,
whose
now you
favor?
see, now you see,
In
you
whose
have,
favor?
you have shown me two documents of the deputy commissioner and the high court, which is not actually connected with.
Not connected with.
No, not
but
connected with,
the
but
learned
then,
court
the
below has-
decision is not based on that only.
Yes,
No, decision is not only based on that. There is evidence.
but
Decision is based on the evidence.
what compels the trial court
Hmm.
to bring these two documents and arrive to a conclusion?
No, that you see, so the decision is not only based on that.
If it is not properly considered,
Hmm.
learned court below should be directed to consider and take into consideration of all
We'll
these.
fix short date, we'll fix short date, let them appear. We'll take up your interim.
No, it's
Yes.
being noticed, I have no difficulty, Lordship.
No, no.
But in order to avoid
Notice already
any
issued, short date.
complications,
We'll fix short date, let him appear, let the opposite party appear. Because you see the decision, you just see the evidences. In the evidence,
if the decree is drawn, then I may be compelled to file another application challenging that. So in the best interest of justice, in order to avoid any complication, what injury will be caused if the Indian order is stayed to the plaintiff?
Hmm.
What injury will be caused to the plaintiff if the Indian order is stayed and suspended?
what
He's not
urgent,
losing anything.
what urgent,
He's not losing anything. Therefore, the balance of convenience is in favor of the appellant respondent, appellant defendant. there are many evidences also which have been ignored to be taken into consideration by the trial court. There are many points which was not taken into consideration by the trial court. And rather based on an irrelevant document to arrive to a finding.
You yourself say that you say that they used to pay land rent, but then no records at all. Till 92, till the fire accident, it was under them only since 1947. And then you yourself says that although there had been deal with the others, but then he was never, or he refused to pay tax, or he never entered into, never submitted to you for entering agreement with you,
Lordship may kindly see the permit.
and never
Whether it is
never paid rent to you. And
it is a
Can
land
you see
pata
your-
or a
you see your evidence also. They never paid rent to you.
so, Lordship.
Mm.
And the evidence also kindly see, come to page 50. Whether
it wa-
this
it-
is
it
a land
was
pata
over-
issued by the British owner.
Mm.
It is a permit to open a shop. And this has been converted to a
No,
pata.
that, whether that permission has been challenged. Permission, because permission,
run a shop.
can be given by the person who is
To-
authorized to give permission, and who under who.
Permission to run a shop, I have
Hmm.
no problem. Because to run a shop, land is not
And
taken away.
the basis of your claim is only that it belongs to your ancestral land.
Yes.
Mm. And you say that there is no document.
Even in my village, I have lot of chunk of land. I do not have any document because I have inherited from my grandfathers. For those land, I need not possess a document or pata.
And then you see permission, of course, permission is granted, maybe, or the license may be given by the government, or permission may be given
To
by
run
the
the
government.
shop,
Yes, but
to
then,
run the shop,
but then you
let
see,
him run.
but then
No matter.
they have constructed a permanent structure over there.
Yes.
You have never objected to that.
Why should I object?
And for
Why
1947
should I
till
object?
92.
That cannot be the ground.
Mm.
By constructing a building in that land,
Mm.
doesn't mean that my land has been taken away. So why should I challenge? And to run a shop also, it is
So-
up to them.
Since 47, and then you see,
have
as
been
you know,
taking land
that
tax.
the land,
You have been
under
taking land tax.
land, no, land tax, he never paid, he said. And even just see your
He paid.
evidence, see your evidence.
He paid,
No, see your evidence also. He never paid.
but he was under the under the permission of the landowners.
No. It's not a permissive occupant. He was not a permissive occupant either, because he was permitted by the government. Government given him the, authorized him to,
Open a shop
Construct.
only.
no. And then
For
subsequently
opening a shop, I have no
constructed
objection.
the permanent structure there.
Yes, he may have constructed the structure also.
You have never objected to that since 1947,
When the
before-
title has
before
not been taken
independence.
away,
and then
I have been
till
taking
92.
tax.
It's difficult, little difficult.
I have been taking tax.
And thereafter also, after 1992 also, he never agreed that, because according to him, the land never belongs to you. It belongs to
Obviously, he may like to run the shop.
Hmm.
He may not agree.
So it will be a little difficult. So let us hear both the parties. This for the moment. Let us hear both the parties.
In that case, there is no meaning of filing the appeal.
No, you see, it will not be immediately executed. Because you said, you yourself
No,
have
no, no.
submitted.
If Lordship is of the opinion that it will not be executed, then Lordship may pass an appropriate order
Hmm.
to that will protect me. Otherwise, the title has been already conferred to the,
So what we can,
Plaintiff,
what
defendant.
best we can do is that till then, so status quo shall be maintained till next date.
no, Lordship.
Because you said
Order
that
has
it is under
already
your
been passed.
possession.
Order has already been passed by the district judge. already given a stamp on the title of the plaintiff, then I become nobody. So the only option is to challenge this order.
So we'll fix early date.
Lordship
Will
may
have-
fix an early date,
So
but
let it appear.
in the meantime,
It's not very far away.
in the meantime,
Hmm.
this judgment may be suspended. Otherwise,
Hmm.
it will be infructuous, meaningless.
So under the facts and circumstances, it's a little difficult. I've seen the evidence.
There are a lot of evidence in my favor. There may be
Yeah.
evidence in your favor, but
No,
the
ex-
conclusion has
Except
been
you
based
shown-
on two documents.
You have shown me the two documents, which
Yes.
is not very connected with.
Is it proper, Lordship, after conclusion of the hearing,
Hmm.
some documents are filed by any of the parties
That of course, that's part
and
of it.
without any letting the evidence arrive to a conclusion
Hmm.
basing on that, number one. Number two, whether a short permit can be treated as a land pata. That too by the Britishers, where the Britishers has given the pata allotment. No document. Without any document, the finding has been arrived by the district judge. That is what I'm questioning, Lordship. See the finding. Britishers has given the allotment. British government from which document this conclusion has been arrived. British government allotted the land to let so and so, grandfather of the present appellant. Basing on which document this conclusion was arrived? Which evidence also? There is no evidence, no document. From nowhere this conclusion has been arrived. If this honorable court do not interfere with such kind of a finding, then where the plaintiff will, appellants will go? When the case has been decided by ignoring the documents and contrary to the documents,
Where in the in the impugned judgment, we find that these two document has been placed after the evidence was recorded, after the hearing was done.
Lordship, we
impugned order,
kindly
no?
see the date of filing.
Hmm?
Date of filing the documents.
No, whether in the impugned order anywhere, has it mentioned?
That is the reason I'm challenging. Kindly come to page 244.
No, in the impugned. Okay, just one sentence. No. The Land Council for the petitioner submits that the suit was finally heard on 23/5/2022, and a judgment was pronounced on 19, sorry.
1,
Just a minute, huh?
2024.
Suit was for hearing, and thereafter, and thereafter, on 25/5,
27/5. 27/5. 2022.
on 27/5/2022, there are two documents
Yes.
dated, namely, order dated 25/5/2007, passed by DC Mokokchung, marked as document 1, bracket close, huh? Within bracket, and order dated 23/2/2011, passed by the Honorable Gauhati High Court, marked as document 2. Were submitted before, were filed after the matter was finally heard and the judgment was passed on, but judgment was passed after
1 year, 8 months approximately. Judgment was passed on 19/1/2024.
1 year, 8 months. After about 1 year and 8 months on 19/1/2024, basing on the above. And then basing on the above
Two documents.
two documents subsequently submitted by the respondent plaintiff staff. That is in the above, with along with that main line, Okay, then the issue notice will come, Now this decree not yet drawn, so it may not be proper.
No, what prejudice will be caused to the plaintiff if the stay is granted, lordship? When the matter was heard after 1 year, 8 months, during that time also it was in our possession. And if the stay is granted, what prejudice will be caused to the plaintiff? Therefore, lordship, the balance of confidence is in favor of the appellants.
No. So there are some difficulties. We'll have hearing and then definitely we pass order, but then after hearing the part,
Then some interim protection may be given, lordship.
what kind of protection? No, so protection will be given only after hearing, because this, then for again interim, I need to
Then
justify.
in that case, the appeal will become infructuous.
No,
No point.
no. We'll fix early date, not 4 weeks, we'll say 2 weeks.
15 days already lapsed.
No,
They will throw the decree.
decree not yet drawn, you said.
We cannot say that, lordship,
No, it will not be immediately executed.
but
So it will be hard. the
That
interim will
observation may
taken
be
up.
made. some observation may be made, lordship, so as to protect
What?
the appellant.
Hmm?
Some observation may be made that decree will not be executed. Otherwise, anytime they will execute the decree.
In
That
execution,
is the reason why, lordship, I'm submitting that in the interim, the impugned judgment will be suspended. And what prejudice will be caused to the plaintiff till the next reasonable date only.
no,
And if it is not
no-
proper, then lordship can
no
vacate.
prejudice will also cause to you either, no,
Why not?
at the moment.
The land was in my possession, it was taken away. That is the prejudice. That too relying on a document which has no relevancy with our case. And that too basing on a document where a show premise was issued. And the learned court below came to the conclusion that it is a land permit issued by the British government. From which document the learned court is arriving to that conclusion, lordship? At
No.
least
No.
they
so
should be able to show.
I've seen the evidence. So
This is also one of the evidence.
So
This is also one
under
of
the
one part
circumstances,
of the
under the
evidence.
circumstances, I need to justify for passing interim order also. That is why. So we'll give 2 weeks only.
In that case, lordship, the appeal will become infructuous.
No,
Why not? Order is already there. Nothing has stopped to execute the order, to implement the order, unless there is some order by the higher authority, higher court.
so unless the decree is drawn, they will not be able to proceed with the execution of.
They will throw the decree.
Hmm.
Direction will be issued. already issued to throw the decree.
So who is this now sold to? This was also used third party also involved, it appears.
We cannot go beyond the pleadings.
Hmm. Now, in the order itself, it is mentioned, it was already now sold to someone. As retired officer.
It was not sold to anybody. IAS retired officer is one of the persons who is the boundary.
What, so I'm not inclined to for this interim at the moment. So what protection, what kind of a protection you want now? Interim will be taken up only after hearing both the parties. So in the meantime, how do I protect?
No action may be taken basing on the judgment.
Okay. So till,
No decree may be thrown till the next reasonable
no
date.
decree drawn, we can't. So because that will be the basis of your challenge only. You
No,
will be
no
challenging the
protection
decree.
in that case, no protection in that case.
Hmm?
If the decree is not suspended, there is no protection. This honorable court will allow this judgment to continue. And the filing of the appeal will be meaningless.
No, we'll clearly say that the interim will be taken up on the next date, giving
Yes,
short
but
date.
before that date, if anything is happened, then it is meaningless. Appeal become infractious.
In the meantime, till the returnable date. We'll say status quo. Status quo over there, huh?
That has already been taken away by the ambient judgment.
No, over the
I was
fruit land.
occupying the land,
Hmm.
but by this order, the title has already been given to the plaintiff.
No, but then the status quo over the land. Status quo, you will not be evicted because you said that it is under your occupation. You will not be evicted.
It was under my
It will pass
occupation, but
status quo.
after the judgment, it no longer remains with me because the entire title has been conferred to the plaintiff.
No, title is it is under challenge. That will be taken up on the next date. Interim.
Status quo will not protect me, Lordship.
Then it
Because
is under no, not under your is it not under your possession?
we were under possession,
Then-
but up to the judgment, I cannot forcefully occupy. I have to respect the law. Rule of law will be maintained. Otherwise, if I occupy, still
So
it
you
will be illegal.
So you want that you will not be evicted based on this judgment.
No, no. Already I have been dispossessed from the land by the ambient judgment. That is the reason why I am seeking stay of the judgment. Otherwise, entire title, rights, interest, everything has been granted to the plaintiff.
No, no. You said that the land in question is physically under your possession.
It was under my possession till the pronouncement of the judgment.
Hmm.
But if I still occupy this, that will run contrary to the order passed by the district judge. Because the district judge on 19/1/2024,
Hmm.
rights, title, interest has been restored to the plaintiff. That means I'm no longer occupying. And if I occupy, it will be contrary to the law.
So in the meantime, pursuant to the judgment and order,
No step may be taken.
no?
Steps may be taken.
Okay. In the meantime, till the returnable date, it is provided that pursuant to the judgment and order dated 19/1/2024, no step may be taken to evict the appellant.
No, that will suffice.
Not,
Lordship.
okay, no step may be taken. Okay,
Otherwise, there may be complications, Lordship. That is why
so this is a whole case, complicated case. And then let's see.
much obliged.
For admission, item number 12.
Lordship,
2 weeks, 2 weeks. Huh?
Lordship, the
Mm.
public prosecutor, the person handling the instant case, he is in the other court, and I have discussed with him. So kindly let the matter be listed after 3 weeks, and in the meantime, let the interim continue.
So there is interim order.
Yes, Lordship.
Oh, AB, this is AB.
Yes, interim
Okay.
protection has been granted to me, Lordship.
Mr. Satyanga, land counsel for the petitioner staff. PP is in the other court.
Yes, my lord.
Okay. So we'll not record your name. Okay. Mm. No one appears on behalf of the state. Sorry, the PP is stated to be in.
Court number 1.
So, okay, on leg in court number 1. Staff, the petitioner will just list the matter after
3 weeks, Lordship.
3 weeks. In the meantime, the interim order passed. Earlier shall continue.
Deeply obliged.
Okay.
Orders, item number 14.
May I place your lordship?
Yes.
As per the order dated 11/12/2023,
Yes.
I've deposited a statutory deposit of 50% for stay of this award on 31/2024.
So on by this 11/12/2024, 23, you were directed to deposit.
Yes, your lordship.
There's no order as such. You have filed IA also,
Yes. for
maybe in
stay-
IA.
Yes, your lordship.
This is MAC appeal.
I'm 130.
130.
Yes, for stay. No?
What's matter, isn't it?
Yes, also.
Okay. So this is stay petition. Stay of the impugned order.
Yes, your lordship.
This is an application for. Opposite party has appeared.
No, not.
No one appeared. So the liberty was also given. So have you taken steps upon the respondent?
Yes, your lordship. Last occasion.
Okay. Or Miss Thuekrulu, Land Council for the appellant staff, huh? And the appellant who submits that in compliance of the order passing by this court on 11/12/2023 in IA Civil 130/2023 in MAC Appeal 3/2023, commas. The petitioner has deposited how much amount have you submitted in
Yes, your lordship.
affidavit or proceeds? Deposited a sum of rupees
10,25,500.
10,25,500 being 50%,
Yes, your lordship.
being 50% of the 50% of the awarded amount of rupees 20,51,000. 20,51,000. Stop. Deposited on, huh? On which date you said?
On 31.
On 30/1/2024. Stop, huh? So since the order made clear that the impugn order stayed on your deposition, no need to repeat it.
Yes, your lordship.
Okay. You have taken steps.
Yes, your lordship.
It is still awaited.
Yes.
Appellant taking steps, service notice on LCR also
It's not yet called.
still, no? The office note dated 30/1/2024 confirmed. Sorry. Reflect the deposition of the 50% of the awarded amount by the petitioner. No, rupees, right there, rupees 10,000, 10,25,500 being 50% of awarded amount. By the appellant and staff. The office note 1/2/2024 also reflect that the appellant has taken a step. However, the service of notice upon the respondent number 1, 2, 3 is still awaited. And the service of notice upon respondent number 1, 2, 3 and the LC, so still awaited, and the LCR is also still awaited. Stop. You want to take fresh steps or what?
We'll wait for
Not
some
now.
time.
Okay. Is requested list, list this matter after 3 weeks. Okay. Stop. In the meantime, also issue reminder for LCR. No?
Please, your lordship.
For orders item number 17.
Maybe Lordship.
Yes.
Lordship, Lordship, where is the order dated to me 8/11, Lordship? Lordship here, Miss Apila. She'll be appearing for respondent 2.
For a date dated
28/11. 28/11.
2011. Okay. Yes.
But Lordship, I was informed that she is out of station.
Okay.
Lordship may list the matter up to 2 weeks, Lordship.
You are appearing on her behalf.
No, no, I'm for the petitioner.
You are for petitioner.
I'm for the petitioner. But
You
since
mean-
I was informed by her that she is not.
Okay, yes, yes.
Yes. And since she does not.
Mr. Seko for this, and counsel for the petitioner. Stop, this is criminal petition, huh?
Previously.
Also, Mr. Kiangami, public prosecutor, staff. So this is fixed for what?
Lordship, admission is in orders, Lordship, because the respondent 2 has not appeared. She has
Oh,
not
not
filed
yet
her.
appeared.
She has not filed her Bagalatma, Lordship. As far
Okay.
as I'm
Okay,
aware, but since
Hmm.
she has appeared last occasion.
okay. It is informed that who is out of station, Miss
Miss Apila Sangtam
Akila, who appeared earlier on behalf of respondent number
2.
2, is stated to be out of station. Stop. In view of the above, list is matter after. So, just a minute, huh? They have not filed land counsel for the petition. So, you wait to, notice was to be published in the paper.
Lordship, but as
Have
per
you
the
done?
CRPC, publication, there is no provision for publication.
Okay, in the criminal.
Yes, that is
Gotcha.
one.
So what do we
issue,
do
but-
now then?
But since the council, Miss
Hmm.
Apila is appearing for respondent 2,
Oh, it's already appeared.
yes,
Then
Lordship,
Not
as per the
required.
order dated 28/11/2022, 23, Lordship.
Mhm.
Lordship, there is the order that she'll be appearing for respondent 2. So since
Okay.
that publication
Okay, in
will not
view
be
of the-
required.
In view of the above, list is matter of after
2 weeks, Lordship.
2 weeks. Okay.
Lordship is an interim. Can interim.
Okay. What is the interim order?
Staying the proceeding of the CGM, Lordship. The GR case before the CGM, Lordship.
Okay, in the early, in the meantime, the earlier order.
Interim is already 4/8/2023.
Okay. In the meantime, the interim order passed earlier shall continue till next session. Okay.
I'll oblige, Lord.
Okay. Thank you.
Kalau di lagi dari mana? Mau itu pernah di dulu. Seperti ini.
Right.